May it please the court, my name is Charles Lincoln. I represent the State Aid Tax Authority. Our position is that the court should find that the CFC Controlled Foreign Corporations rule does not violate the State Aid Tax Treaty. There's sufficient evidence to support a prima facie case for the tax assessment against the taxpayer applicable against companies having a shareholding in State B. Both elements of the CFC rule are a matter of law met. The elements of the domestic law are that at least 80% of the shareholding be maintained in the CFC and that the domestic tax rate of the CFC country be at least less than 0.5% of the state aid tax rate. Here we have both elements met because the whole shareholding is 100% and the tax rate is 4%, which is less than 20%, less than half of the 20% in state aid. The main problem that the court needs to determine and resolve is whether or not international tax treaties, specifically the State Aid State B tax treaty, is compatible with the Controlled Foreign Corporations rule. It's a difficult question to answer because there is no explicit mention of the CFC rules in the tax treaty model or in the tax treaty commentary, specifically stating that CFC rules are compatible with the OECD model following the 1992 commentary. The crux of this main contention seems to be that CFC rules result in attributing controlled foreign corporation profit to the controlling shareholders. The shareholders out of the parent subsidiary, a parent company that is, even though such profits were never distributed by the CFC. This fundamentally contradicts the basic concept and structure of the OECD model, where there were never profits distributed or cross-border income sent. There was no application of CFC rules or withholding taxes. Indeed, there is no tax court with international tax jurisdiction to resolve these issues, so it is important to look at decisions from various domestic Supreme Courts viewpoints and to see how they came to different decisions and analysis points. It's also important to know that the European Court of Justice tries not to answer issues of tax treaties between countries. The OECD Model Convention on Income and Capital specifically refers to CFC legislation in the commentary since the 1992 update. It is interesting considering that the first CFC rules came about in the 1960s under the Kennedy administration, and they were only mentioned in 1992. In any case, the 1992 commentary existed until 2003 when it was revised in part. The former commentary focused on substance over form transactions and subpart F type rules leading to transparent tax liabilities. The 1992 commentary itself does not indicate that domestic rules of anti-avoidance are compatible with international tax treaties. Moreover, the 1987 OECD report on conduit companies confirms this view that CFC rules are indeed compatible with international tax treaties. There are two cases on point that represent the antithetical approaches to this problem, answering the question of compatibility. There's the Finnish Supreme Court that stated that CFC rules are compatible with international tax treaties, and the French Supreme Court that said they aren't. The Supreme Court of Finland in 2002 held that the OYJ-ABP case stated that Article 7 of the 1976 Finnish-Belgium tax treaty does not prevent taxation of the Finnish parent company under the CFC rules, according to the domestic Finnish laws. This is true even though the Belgian subsidiary did not have a permanent establishment in Finland that would provide for taxation under Article 7, and that the residency test of effective management was based in Belgium, and it was not controlled in Finland at all. The Finnish Supreme Court admitted that the classification of the CFC income attributed to the shareholders pursuant to the CFC legislation was ambiguous. Thus, the classification had to be decided on a case-by-case basis. Despite the fact that the Finnish CFC rules were based on deemed profit approach, the deemed dividend distribution, that the disregarded legal entity approach was not used and the deemed distribution was, the court qualified the Belgium CFC income as attributable to the Finnish parent company as business profits, not as dividends or other income, and consequently analyzed the problem of compatibility between the CFC rules within the Article 7 framework of the Finnish tax treaty. The court decided that the CFC rules are compatible indeed with Article 7, and that the basis of the treaty, its purpose based on the 1987 OECD report on double tax conventions and the use of conduit companies and the commentary released in 1992, version allowed secondary sources to be used, and using these secondary sources, they found four main points. That tax treaties based on the OECD model tax convention, for instance, the Finnish-Belgium tax treaty, do not aim to avoid double economic taxation, but only double juridical taxation. And the Finnish CFC rules do not result in double juridical taxation themselves, regardless of whether the possibility of double economic taxation was incurred. The object and purpose of the tax treaties is not to avoid double juridical taxation, but also to avoid international tax avoidance. This even follows from the French. This leads us to point number 3, that tax treaties do not prevent the application of domestic anti-avoidance rules, including CFC rules. The large majority of OECD states regard CFC rules as compatible with international tax treaties. Thus, this all goes to show that the Finnish Supreme Court held that CFC rules, domestic anti-avoidance rules, are compatible with international tax treaties, specifically the Finnish-Belgium tax treaty from 1976. The French Supreme Court, on the other hand, came to the opposite conclusion, that international tax treaties are not compatible with CFC rules, specifically relating to the domestic French CFC rule and the France-Switzerland tax treaty. One of the main points of coming to this conclusion was that there was no specific provision safeguarding the application of French-controlled foreign corporations rules. In this case, the court found that the application of the CFC rules violated Article 7 of the tax treaty, and combating international tax evasion per se on its own cannot justify violation of the tax treaties. It seems that the French Supreme Court assumes that the income attributed to it and subsequently taxed in the hands of the parent company under the CFC rules constituted, in fact, the income of the profits of the enterprise in Switzerland, where it had no permanent establishment in France. As a result, pursuant to the tax treaty provision patterned on Article 7 of the OECD model, the income might be taxed exclusively in the resident state of the company in Switzerland. The outcome in this ruling suggests that the court thought that the main object and purpose of the tax treaties is to avoid double taxation in cases when income is taxed in the hands of different taxpayers. The court regarded taxation in the hands of the Schneider SA, which was the company in France, and its subsidiary in Switzerland under domestic tax law, led to economic double taxation, not to juridical double taxation, and thus was not allowed under the international tax treaty between Switzerland and France. Although if we're considering OECD countries specifically that have considered the concept of compatibility between CFC rules and the OECD, it's important to look also to other Supreme Court cases from other OECD countries, specifically Sweden and Japan. The Swedish Supreme Court, in fact, construing the 1987 Swedish-Swiss tax treaty, in 2008 decided, without even looking to the treaty of itself, that CFC rules and the treaty for avoidance for the tax treaty based off the OECD model were not in conflict. Indeed, Sweden came to this result and concluded that this is a case of conflict between the two equivalent legal acts, given the dualist constitutional nature of the Swedish Supreme Court. Due to the fact that Sweden is a dualist state and the Swedish CFC rules are of a later date, the act of incorporating the treaty, the latter prevails. This means that the court solved the problem based off the international principle of lex posterior derogate lege prior. Without looking into the Swedish tax provision at all, it found that the CFC rule came at a later time than the Swedish tax treaty, and thus the later law replaces the former law. The Japanese Supreme Court held that in the Geo Hai case that the Japanese CFC rules were compatible with Article 7.1 of the Japanese-Singapore Treaty from 1995. The court claimed that the application of the CFC rules results in taxing income of the Japanese shareholders, not income of the Singapore CFC. Consequently, the court decided that such a decision does not violate Article 7.1 of the tax treaty. The court also referred to the OECD commentary, Article 7.1 of the OECD Model Convention, and concluded that the OECD commentary clearly states that CFC rules do not violate the OECD Model Convention and their application is widely accepted in the international community. Now, to summarize these cases, it should be noted that the CFC rules was based on the deemed profit approach rather than the disregard legal entity approach. Now, in conclusion to all these cases, we have the Finnish Supreme Court that finds that CFC rules are compatible under the dividend distribution approach. We have the Japanese Supreme Court that finds that CFC rules are compatible under the dividend distribution approach as well. We have the Swedish Supreme Court that finds that CFC rules are compatible on the concept of lex posterior, the later supersedes the earlier law, based on the dualist system of the constitutional system of Sweden. And we find that these cases should in total be taken to show that they trump the lone-standing French Supreme Court case that CFC rules are not compatible with international tax treaties. The commentary, now looking to the commentaries and whether or not they should be used to interpret the treaties themselves or using newer materials to interpret older materials, it should be noted first that there is an overwhelming amount of evidence that indicate that the OECD countries have used the commentaries to resolve a wide variety of legal disputes, and that this court should feel that these commentaries being used is a matter of jus cogens, an international norm. Indeed, even international scholars interpreting these international issues, such as Avery Jones, Michael Lang, and Florine Brugger, all argue that there is a possibility to claim that in certain circumstances, newer versions of the commentary to the OECD model may be used to interpret older tax treaties. It may be permissible if the wording of the newer commentary is only sensible interpretation of what was already written in older versions. Besides, it should be determined to what extent such a dynamic reference to the later versions of the OECD commentaries is permissible under constitutional law of the contracting states. The courts should adopt an ambulatory approach rather than a static interpretation. The ambulatory approach has three main great functions that allow a dynamic reading of the OECD model. First, it's because an ambulatory allows this court to meet the present-day needs, not make a ruling based on the basis of obsolete, outdated, withdrawn, or even invalid rules that is impartable and would lead to an unreasonable result. Moreover, the European Court of Human Rights stated that a treaty is a living instrument, and even going back to the EHRR, the predecessor of the European Court of Human Rights, a treaty is a living instrument and should be construed in the time that we're living in. And moreover, horizontal equity calls for this because the concept states that between taxpayers an exact year given the same position but for the same date of the conclusion of the application of the tax treaty, here we have similar facts but a different date to the former cases at hand. The counter-arguments to an ambulatory interpretation is a static interpretation. There are several counter-arguments. First, pacta sunt servanda holds that treaties should be interpreted in good faith. The concept of jus cogens and preemptor preempts this because international laws have shown us that commentaries should be used, and an overwhelming amount of precedent has been used to indicate that this would be in conformance with pacta sunt servanda, and we shouldn't apply the static interpretation. Another concept is the concept of legal certainty. Now, Your Honors, the concept of legal certainty usually applies to criminal cases. Indeed, it exclusively applies to criminal cases in the U.S. Supreme Court case, Calder v. Bulf, since 1798. It says, quote, a passage of an ex post facto law applies exclusively to penal or criminal cases. Now, granted, this is a 1798 case, but at the time the court considered French civil law as it was in its nascent stages under the newly introduced Napoleonic Code, and it took this basis off the Anglo-Saxon system of common law based in the United Kingdom. However, it's also important to note that this has been upheld 264 times by the U.S. Supreme Court, and most recently in Pugh versus the United States, stating by overwhelming consensus that legal certainty is not a constitutional protection for non-criminal cases. And finally, vertical equality would be the final argument for a static interpretation. However, we find the state aid tax authority contends that between subsequent and factually identical tax years of the same taxpayer, this would be allowed. However, this is not a factually identical tax year or the same taxpayer of these exact similar facts. In conclusion, we are urged the court to consider the commentaries and the newer version of the commentary that says CFC rules are compatible with international tax treaties. And moreover, in conclusion to the entire arguments, we contend that an overwhelming majority of CFC domestic Supreme Courts have ruled on the issues, have determined that CFC rules are compatible with international tax treaties, and the commentaries of an international jus cogens should be taken in conjunction to support tax authorities' side for leading to the conclusion that the State A CFC rules are compatible with the State A State B tax treaty. Thank you very much for your time, Your Honor.